Okay, well, thank you everyone for joining us for the 2022 Canadian Email Summit. My name is Matthew Bernhout, along with Derek Lackey. The two of us worked very hard to found the Email Summit in 2019 and have been carrying forward. This is yet again another virtual event for everyone to attend. Very excited that you're all here. A few housekeeping notes. We are going to be recording all of the sessions and we'll make those available after to the attendees. So please do keep an eye out for that. It'll take us probably a week or two to process all the video and get it up on the website and share that with you all. Please do ask questions in the question box at the bottom of the window to our speakers. They will come at the end of the session and answer the questions. And we have a really solid 2 days of content, both afternoons. And we're really looking forward to you joining us. Just want to thank our sponsors, iContact, NetCore Cloud, Newport Thomson, and our partners, the Response Marketing Association, for again making this event possible like they have in previous years. Very excited to move forward. For today's starting session, we're going to start with privacy and privacy changes in Canada. There's a lot of things going on, from changes in Quebec to new federal legislation that is working its way through the system. And I'm really excited to see what Derek Lackey and Alison Cross have to talk to us about today. Thank you both for joining us, and I'm going to turn it over to you with 1 minute over. So thanks again for joining us today.
Well, sounds like Derek, you're on mute.
Good. Thank you, Alison. Thank you, Matthew. I'd like to begin by introducing my co-panelist, Alison Cross, who is the Vice President, Marketing and Communications for Ontario SPCA. And as a marketer, has recently undergone from scratch, implementing a privacy management program throughout the entire company. And as the marketing lead, Alison has taken on privacy as under her umbrella. And maybe you could just say a little bit about that, Alison. These changes, particularly with Quebec's change, kind of sets a new bar here in Canada. I'll explain a little bit more about that later, but maybe you could explain, Alison, why as a marketer you thought it was necessary for marketing to own privacy.
Well, that's a good question. One of the big things, again, the Ontario SPCA is a charitable organization, so we rely on donations to keep ourselves operational. So with any organization or any company, it is very important to build that trust with your customers. But for our donors, that is a top priority for us. We can't survive without them. And so we rely on them to know that they can trust us and that we are being lawful with all of their data and their contact information. So that was a huge priority for us. And seeing that the marketing and communications department and works very closely with our development department, our fundraising team, that we are the ones that talk to the public, and we're the ones that create that connection, and we're the ones that capture majority of the data and use the majority of the data. We felt it was really important that the privacy officer role stay with marketing, because we can make sure that when we are executing the use of that data, it is being done lawfully.
Awesome, awesome. And just for full disclosure, Newport Thomson, which is my company, my commercial company, I'm also the chairman of the Response Marketing Association. But Newport Thomson is working with Ontario SPCA to implement this program. And I would say we're about 60% implemented. And maybe you could talk a little bit, Alison, about the process so far, how the teams embraced it, maybe a little bit about what surprised you about implementing privacy as a marketer.
Sure. So we started out by doing an audit. We wanted to understand exactly where we're capturing data, where it's being stored, and then how we're utilizing it. So that generally gave us an idea that we're actually doing quite well. But where the gaps were is we didn't have any formal policies on paper or on digital paper outlining exactly how we're storing that data, the rules around it, any of that. So even though we were doing quite a good job at being secure with that data, there is no documentation on that process. So we decided to create a manual, which is part of a requirement under the new legislation. And so that's the process we're going through now, is creating that manual, putting our policies down on paper and creating the proper documentation so that if we're ever challenged for anything, that we can easily capture it, and those who are inquiring can have faith that we are utilizing that data lawfully and securely.
Excellent, excellent.
Mm-hmm.
I'll just address a couple of things that Alison said there from the new law's point of view. There are a tremendous amount of obligations, new documentation obligations for every organization in Canada. So why Quebec's law applies to most Canadian companies, most companies doing business nationally in Canada, is that 25% of your database is likely to be from Quebec. Therefore, PPIPS, the new privacy bill under Bill 64, applies. And I think there's a lot of companies who think, well, we don't have an office in Quebec, so it doesn't apply to us. It doesn't matter if you have an office there. It only matters if you do business there and you have Quebecers in your database. And that really is the criteria. So don't be fooled that it doesn't apply to me. It's this sets a new bar in Canada for privacy that I don't even think the new federal law that's on the books will surpass. So we are advising all of our clients, if you're going to operate in Canada, operate to the level of PPIPS. Now, I do have some slides here that I'm happy to share with everybody at the end of this. I am not going to read through all of this stuff, but I left it on the screen so that you could read it. And I will do so with this one. But the main obligations are that you have to have a confidentiality incident reporting plan in place. And that includes policies and procedures for how you handle confidentiality incidents. And the Quebec law defines confidentiality incidents as a data, privacy, or security breach. And they've lumped them all together and are calling it confidentiality incidents. And there is no option on this. You have to report them. So most are going to be self-reported. You have to keep a log of all your confidentiality incidents in the company. And it needs to be made available to the access to information officer in Quebec upon request. But if you have sensitive data and it is breached in any way, privacy data or security, you have to report to the guy immediately. And you have to determine with the guy whether or not you have to communicate with the individuals involved. So there's some very distinct levels that they've done. Now, most data protection laws around the world have included confidentiality incident response planning or data breach planning, and even in PIPEDA, but there's no enforcement of it. The difference with Quebec is there's going to be enforcement of it. And they made that one of the first things to come into force, which starts tomorrow on September 22nd. There are 3 things that come into force. And Alison, correct me if I'm wrong, but one of the things that put it on the Ontario SPCA's radar was the fact that the highest authority in the company is now accountable for all personal data, managed by that company and for compliance to this law?
Absolutely. That was one that as soon as we realized that, because that could not only apply for our CEO, but also our board of directors. And that's a group of volunteers. So we want to make sure that we're protecting them, as well as, again, a big priority for us was to build that trust with our supporters.
Yeah. Yeah. So there's really three key things coming into force in a couple of days. The confidentiality incident reporting planning, acknowledging in writing the fact that your CEO or the highest authority in your company understands that they are accountable for all personal information held by the company and used. And the third thing is, if you're using any biometric data, there are some things you need to pay attention to. Most companies aren't yet using biometrics. So we're not going to get into too much detail on that. Alison, what do you think the team has learned collectively?
We've had a lot of great discussions. So one thing that I did when we started to develop this manual, I created a committee, and that had involved with members of any department that had a big say in how data was stored or used. So we have someone from our fundraising team, someone from finance and IT, our website, webmaster, myself. And then as we unfold and execute this plan, we might involve more people from our team, depending on who might be the subject matter expert for us. And so as we've been going through developing each chapter of this manual, we've created a lot of really good discussions about how we operate, and what was once a standard practice may not actually be a lawful practice not right now, it's still lawful, but when moving forward, it might not be lawful. Great example is how we do our digital ads with Facebook and Google. Right now, there's the opportunity to exchange data in order to tailor our ads to specific audiences. And that might not be something that we can do in the fashion that we have right now. We might have to have a formal agreement with Facebook and Google. So recognizing we are just a grain of sand in a giant beach to Google and Facebook, we're looking now at, okay, how do we operate? How do we move forward doing our digital ads if we can't do it the same way we've been doing for the last 10 years?
Yeah, one of the other things that's going to be affected by these new data protection laws is cookies. They're also being phased out, but that third-party tracking is not going to be available to us. So we're going to have to rethink some of our marketing practices, and I think it's a good thing. We collectively, as a business community, have taken liberties with personal information that I'm just going to bottom line it and say we've gone too far, and we need to be pulled back. And the only way to pull it back, in my opinion, is to set legal guardrails for what you can and can't do with people's data. And that's what we're seeing around the world with the GDPR, the CCPA in California, and now PPIPS here in Quebec. The federal law, I'll just comment, it's called Bill C-27, is currently being considered. And it's way less stringent than Quebec's law. So we believe if you're compliant with Quebec laws, you're going to be in better shape in doing business across Canada than if you go with this new federal law. Sorry, I see there's a question. You mentioned that the last comes into force on September 22nd. Is there an onboarding period? So the onboarding period, I'll answer that right now, started last September 22nd when the bill came into force. They gave us 1 year to operate the first, for the first set of things to come into force, elements to come into force, which were the three I mentioned. And they gave us a year to put that in place. Some people have taken advantage of that year, but quite frankly, not many. So there's going to be a lot of scrambling to catch up. By next year, next September 22nd, 2023, most of the other components of Bill 64 will kick in. And those are the heavy ones. Those are the having documented policies and procedures, having data impact assessments, lots of documentation, documenting consent. You're going to have to prove consent, much like you do today under Castle, where if questioned by the authorities, you have to be able to prove whatever you're claiming. And quite frankly, most of us are not set up to track consent and do it in a simple, easy way. There are great automation tools out there, but most of us have not yet deployed them. So I think that we're in for a very interesting year. And, you know, Alison, I'll ask you, when is the right time to get started?
Honestly, anytime is the right time to get started. It is a big project. I'm not going to lie or sugarcoat it. But that's the thing. I think it's with any big project, you just kind of got to get started. I think doing the audit at first was a great starting point because we understood what we already had going for us and where it flagged something areas that we need to work on and clean up. And then, you know, once you put it together, your committee so that you had your team of experts, it doesn't seem as overwhelming. We go chapter by chapter, putting together what is needed and putting together what's going to work for our organization. So to give an example, when we're working with Derek and they're giving us the highest standard of what we want to achieve. And for us as a nonprofit, that's our goal, but we might not just be able to get there this year. It's just not necessarily feasible to be able to do that. Now, again, our practices are still lawful. Our goal is to make it simple for whenever we are asked about how we operate or challenged with any type of data usage, we can easily access that information to prove how we're using it and our policies and procedures. And so we're working with Derek on finding ways that we can still do that without having to go to the solid standard that he's set up out for us. Then the goal is that we will get to that standard as we continue this practice moving forward.
Yeah, and I think that's a great opportunity, Alison, to distinguish between the minimum required by the law, which is called compliance, and taking care of your customers. Mm-hmm. And you can't change everything at once, like no organization can, because it would just throw chaos into the works. So what we're trying to do is cover off and change the key things that have to be changed ASAP. And then the other things, you know, they can follow along behind. But if you tackle the real thorny issues at first, I think you can make progress. And you cannot do this overnight. Give yourself the year that the Quebec government is giving you. Give yourself that year and plan out how you're going to do compliance that affects the marketing department. Because if you do not, now here we go, as email marketers, we now have Castle to deal with, and we now have to overlap PPIPS and make sure that we're towing the line on both parts. Now, I will give the B2B marketers a huge sigh of relief. There is a clause. Let me just find it here. I just pulled it out and highlighted it for myself so I could read it to you. There is a clause in section 1 of PPIPS that talks about who it applies to and who it doesn't. And it reads, nor do they apply to personal information concerning the performance of duties within an enterprise by the person concerned, such as the person's name, title, and duties, as well as address, email address, telephone number of the person's place of work. So as long as you're addressing people in their work environment about work stuff, you have some latitude and they don't consider that personal information. So that was kind of a big shoe, because they're not out to make it difficult to do business. They're out to make it easier for an individual to protect themselves in this online world, given what we can accomplish with technology. So just file that away. There is a good B2B carve out, but a lot of you guys as marketers are B2C, and you're going to have to be careful as to whether or not you have consent and whether or not you require consent in some cases. So what there is to address, or what's changed, is that there are PIAs required to privacy impact assessments to determine data minimization. You must have a good reason, a legitimate and serious reason to be using people's personal information. You have purpose limitations. When you collect consent, you have to clearly state what it's for. And no more ambiguous statements like, we're going to keep you up to date. That's not going to cut it. You're going to have to specifically tell people what you're going to do with the data you're collecting on them. Transparency of the source, offer for real choices. So when you're trading lists, transparency of the source is critical. Offer real choices for the use of data, so that empower the consumer with a choice. I've had some email folks say to me, well, I don't want it to be easy for them to opt out. And you know what? I think we do. Because if somebody wants to opt out, why would we make it difficult for them? Why wouldn't we just let them opt out? Because our emailing to them isn't serving any purpose other than annoying them. So why would we not make it easy for them to opt out? I would suggest, as a marketer, it should be as easy to get off your list as it is to get on your list. And the companies who do that, I know I've dealt with Basecamp for years, and they make it as easy to cancel your Basecamp subscription as it is to start it. And I love that about them. And I've stopped and started it literally a dozen times over the last 7 or 8 years. And I love the program, but sometimes I just don't have a use for it. And so we turn it off and we stop getting the charges for it. And they make it very easy, very easy. And I mean, as easy to get off as to get on. And I think that we should have that attitude about our email subscribers as well. So I have a question here. How does this impact companies that would traditionally be a data processor versus a data controller? There are going to be obligations. The main thing with data processors versus data controllers will be the documentation of the agreements between third parties. And there is requirements in Quebec for it to be clear. So Ontario SPCA, for example, one of the areas that we will be addressing in the upcoming sections of their policy and procedure manual is the agreements they have with the software companies that they participate with, and make sure that the companies they're affiliating themselves with, the processors, are on the same page as them regarding how they protect and use the personal information that they trade between data controller and data processor. And it can't be left to chance. It has to be documented, because when the CI comes in and asks you for your third-party documentation and you can't provide it, they're going to assume it doesn't exist. So pretty important, and a good question. Thank you. The data processor can be given data from the controller without the permission of the people involved. As long as the proper consent and it's been lawfully gained, they can trade it with their data processors, and there's no limitation and no friction. It's one of the differences with the GDPR. There are some requirements under the GDPR there are very little under the Quebec one between data processors and data controllers.
That's actually one thing that we were just speaking of recently as part of our policies is when does the privacy officer for the organization get invited to the table when discussing contracts with our software companies. So it can't be, privacy is becoming such a priority now with the organization that it can't be, oh, we're about to sign, you should check this out. We need to be brought in so that the research can be done and the discussions can be had with the software company to ensure that they are as compliant as we are or more with the data and how they're using it.
Very good. Thank you, Alison. That's a great point. It is privacy by design and default at work. Because if you embed privacy in your processes as you're developing them, I just had the pleasure of being part of the ISO standard 31700 for privacy by design for consumer products. And we developed the ISO standard, a group of international privacy professionals and standards people. We collectively put together these standards, and they really were based on Ann Cavoukian's, I think, groundbreaking work called Privacy by Design. And the theory there is build it in as you're developing the product, build it in as you're developing a campaign. Don't think about it after and just put Band-Aids on from a privacy point of view. And Ontario SPCA seems to be doing that very well. To me, one of the biggest areas is how do we manage consent? We work with a platform in the UK called Serenus. Cassie is the name of the product. And they automate it all. They connect to everywhere you keep data, and they automate, and they give a portal to the consumer so the consumer can come in and change whatever preferences they want at any time. And you have an immutable record of it. And once you set it up, your marketing team doesn't have to touch it. And I love that stuff. That's the kind of automation I look for as a privacy professional. Not a place to put all my documents. Gosh, we can use Google Docs for that. What's really critical is a few functions. So we have another question here. We typically only deal with organizations, so it appears that the exemption clause applies. However, some web visitors only submit their email addresses, for example, via our pop-up, and then end up in our nurture list. Would we be exempt relating to those contacts as well? If they provide it, and you have the proper language around them providing it, you should be fine. Because that's just grown-ups doing business with grown-ups, and none of these laws are designed to prevent that. So, don't get too freaked out about this, but pay attention to the details. And if you haven't read the laws and don't understand them, find somebody who has, and whether that be a privacy lawyer or a consultant like us, or just somebody you trust that has read the laws and understands them, because there are a lot of things that you can be charged for. We believe that the enforcement of the CAI under PPIPS will be strong. They've given, this is the first time they've given finding powers to the access to the information commissioner. And I think they're going to come out the gate strong. And I think the first things they're going to look for is they're going to find some executives, because otherwise they wouldn't have put that highest authority clause in the law. And I think the second thing they're going to be looking for is if you have a significant breach and you do not handle it properly, you will be fined. So they came into force first for a reason. But then there's a whole other laundry list of stuff you're going to have to define by next year. So this is the appointment of a privacy officer and the breach reporting are the two most critical things. And they should be in place for 2 days from now. If you haven't started them, it's going to take you a little bit longer than that, but I'd advise you to get started. So any final comments, Alison?
Just again, that this has been a really, really great process to go through. We'll have brought up a lot of questions, and if we hadn't gone through it, we wouldn't be thinking outside the box the way we are about how to engage our supporters and market to them.
Very good. So it hasn't been as painful as you thought it was going to be.
No, it's actually much more enjoyable than I thought.
All right. We want to end on time. And so back to you, Matthew.
Thank you both.